Okay, good afternoon, everyone.
Hey there. Good afternoon.
Okay, so the topic we're going to cover today is the topic of revenge hacking, also known as retaliatory hacking, sometimes called active defense, affirmative defense, offensive countermeasures, a variety of terms. I'm going to talk very briefly just a little bit about me. Now, I know that you didn't come here to learn about me or find out about me, so I'm not going to dwell on this, but I do want to impart to you some confidence in the material that I'm delivering, that the material that you're going to hear today, that there's some confidence with respect to accuracy and authorities. So I work for U.S. Bank as a cybersecurity partnership manager. I'm involved extensively in work in Capitol Hill with cybersecurity legislation, working through our trade associations and groups. I have a background as a software developer and software engineer, build release engineer. I have a private practice doing digital forensics work. All of my clients are law firms. I teach digital forensics at Century College. I'm also an instructor for ISC Squared. I'm an author of several law review articles, and I'm a licensed attorney here in the state of California. I live in the city. So now I'll tell you a little bit about what got me to this topic of retaliatory hacking. Basically, is that I've had a lot of folks in my industry, information security professionals, that I have learned that really don't have an appreciation for the law. And what I mean by that is the law governing the work that they do. And this is something I really complained about a lot because I feel like we don't have enough training on ethics in our digital forensics programs around the country. There are very few specialized courses just on ethics, and yet I encounter ethical dilemmas all the time in my practice. Certainly lawyers have to be certified on ethics. We have to take an exam to be licensed. We are subject to a very robust disciplinary system for ethical violations. The American Psychological Association has a pretty robust model, but there are no real standards and certainly no enforcement in our industry, in the information security industry, despite the ethical dilemmas that we encounter. And so, as I say, I've met a lot of folks, a lot of practitioners in our business who don't understand the law. They believe that, hey, if I put a honeypot out there, if I have a database seeded with honey words and someone uses them and I discover that, then I know that that must be a bad guy, and therefore I can do whatever I want. It's fair game. And it's not fair game, as we'll discuss later. Something that just came up recently in the news, Bloomberg revealed and confirmed a long-standing rumor for the last year and a half or so that the FBI is in fact investigating retaliatory hacking by one or more of the banks with regard to the distributed denial of service attacks that we suffered back in 2012 and 2013. So the backstory on that is that we had some massive DDoS attacks that took down many of the banks for a period of time. The United States attributed that to an Iranian group. Sandy, recall the name, the full name of that group?
Which one? Al-Qassam Cyber.
Thank you. And there was a meeting with the FBI, it was an unclassified meeting with the FBI and some folks from the banks, and someone from JP Morgan said, well, why don't we take down their servers? And there was some chatter in the room, and folks said, no, it's probably illegal, let's not have any more talk about that. But then, indeed, a few days or a few weeks later, those servers were taken down, and now the FBI wants to know why. If we get a chance, we'll probably talk a little bit later in the presentation to explore the reasons why the Department of Justice would be interested in enforcing the laws concerning this. So that's kind of the motivation for me to get into this topic. I think it's a very interesting topic. I think you're going to enjoy what we're going to talk about here today. You're probably going to have questions. If you think that the questions that you have are going to contribute to the content for everyone else to hear, then please interrupt me. Otherwise, I rarely am able to get finished with this presentation in an hour. I've given it many times, and I'm not able to get all the way through it. So if you think the question is something that should be safe or offline, then do that, and we'll talk afterwards, either individually or even as a group if you want to hang on. Of course, this presentation is not legal advice. You should not act or refrain from acting based upon anything I discuss here. This is for academic consumption and for your edification, and I certainly encourage you to share this information with your students. Okay, so How we're going to go through this presentation today, I'm going to start by defining some key terms and concepts for you so that as I use them throughout the presentation, you'll know what they mean. I'm then going to talk about the statutes. It might seem odd that I would talk about it in this order, but I am going to go through the statutes and give you some understanding for what they are, what conduct that they prohibit. And then as we then go into the next topic, we start talking about the various approaches to active defense. You'll begin to understand and connect the dots, and you'll be able to yourself realize which ones of the statutes are implicated. If we have time, I'll talk about some of the rather odd theories rationalizing active defense. I think they're odd. And then we'll talk about some alternatives if we have time. Okay, so let's do a little bit of trivia. I'm not giving out any Starbucks cards here today, but let's start with the first one. Can anybody tell me here how many times the Computer Fraud and Abuse Act or ECPA make reference to the Internet? Anybody know the answer to that?
Zero.
Zero. Thank you, Sam. Okay. And this next question really isn't relevant anymore. That's correct. So the answer to the second question would have been 2002 with FISNA and some other legislation, but in fact the President just signed into law 4 cybersecurity acts, one of them being FISNA reform. Another one that codifies the National Cybersecurity Communications Integration Center in Washington, D.C., and a couple of others. None of them really do anything important or substantive. FISNA has some important impact, but the ones that we've been pushing for, information sharing and liability protections, a little bit out of the scope of the presentation, but that was not passed. We hope that in 2015 we're going to have a robust discussion on that and get something passed in regards to those issues.
You can jailbreak your phone. That's awesome.
Okay, so let's talk about some terms here. I mentioned some of the synonyms for active defense. We have hackback, retaliatory hacking, revenge hacking is the phrase that's used in that Bloomberg article that I mentioned. Offensive countermeasures is another term. One way of defining it here appears on the screen, but I'd like to offer you some alternative definitions. This comes from my law review article. If you're interested in seeing the article, it will be the last slide, but you need not do that. You can just go out to Google and type in retaliatory hacking and Harrington, and you'll come up with the article right away. Download the one from Richmond Law School. That's the most current one, the one that was published. Let me give you a definition here from my article. Process of identifying attacks on a system and, if possible, identifying the origin of the attacks. Backhacking can be thought of as a kind of reverse engineering of hacking efforts where security consultants and other professionals try to anticipate attacks and work on adequate responses. Another definition that I like is turning the tables on a cyber hacking assailant, thwarting or stopping the crime, or perhaps even trying to steal back what was taken. And yet here's another one, and this one I think I like the best. This was offered by CrowdStrike, which is an organization that's been associated extensively with active defense. And their definition from their website at the time of my publication was deception, containment, tying up adversary resources, and creating doubt and confusion while denying them, that is to say the hackers, the benefits of their operations. Let me read that again. Deception, containment, tying up adversary resources, and creating doubt and confusion while denying them the benefits of their operations. So those are some good definitions for us to work with as we move through this presentation. Now we're going to talk about some of these statutes in detail. The Computer Fraud and Abuse Act, 1986, ECPA, the Electronic Communications Act. There are 3 parts of ECPA. You probably all heard of the Wiretap Act, which dates back to the late 60s, the Stored Communications Act, pen register and pen trap and trace devices. We're not going to talk about that in any detail. Title 18, 2252 deals with child pornography, and you may be wondering, well, how's that implicated? I'll get into that in a few minutes. And then finally, and very importantly, most, if not all, states have counterparts to the Computer Fraud and Abuse Act and to the Electronic Communications Privacy Act. Some of those statutes in those states are very broad and encompass a much wider or broader range of behavior which they prohibit, and some are very, very specific about what's prohibited, more so than the Federal Act, which uses some ambiguous language according to some scholars. So certainly you want to be concerned about your state where you live and what statutes may be implicated. Okay, let's talk about the Computer Fraud and Abuse Act. Directed, believe it or not, at criminal hacking, destructive hacking. How is destruction defined? Well, it's called damage, and damage is defined under the Act as anything that affects or compromises the integrity or availability of data or information systems. Interesting that they left out the CIA there. They're not really concerned with confidentiality. They're concerned with integrity and availability of computer systems and data. The keystone is consent. The keystone to the Computer Fraud and Abuse Act, as well as the Electronic Communications Privacy Act that we'll talk about in a minute, is consent. So what we're talking about here is accessing without authorization or in excess of authorization. Now, there is a circuit split among the circuit courts right now that we hope will be resolved by the Supreme Court at some point in the future, and it really talks about employees who misappropriate data, who exfiltrate data. Now, some circuit courts have interpreted, when I mean by circuit courts, I'm talking about you file a lawsuit in federal court, or when you're a criminal defendant in federal court, and that goes up to one of the 13 circuit courts of appeals around the country. So here we have 2 federal district courts in California, and then there's the 9th Circuit Court, which covers California, and I don't know what else, Utah, Arizona, and some other states. The circuit split is that some of the circuit courts have said that if an employee misappropriates data, that is, by definition, without authorization or in excess of authorization. However, other courts have said no. The Computer Fraud and Abuse Act, as Congress wrote it, did not go to the heart of what the employee is going to do with it. If the employee was given access, then he or she had access, period. That's the end of the inquiry. The fact that the employee did something that he wasn't supposed to do with it, or sold it later on, or used it to be a whistleblower, or went to the press with it, doesn't really matter. If he had proper authorization at the time that he accessed the data and took it, then there's no violation of the Act. So there's a circuit split on this issue right now, a little bit outside the scope of what we're talking about because it doesn't really involve retaliatory hacking. I defined damage a minute ago. At this point in time, it is a felony if the damage exceeds $5,000, and it will also entitle the victim to civil damages. Now, interestingly, if the data that's stolen is intellectual property and you suffer a loss as a result of that intellectual property being taken, that's not considered damage, according to the majority of the courts. Rather, damage is actually considered an interruption to business, destruction of the computer equipment, taking down a server, taking down bandwidth, but not actually the data that was stolen and then you somehow profit from it or deprive a company of profit because it got leaked out. So there are some nuances about what's defined as damage here. Remember that the federal government typically does not consider misdemeanors to be real crimes. So as a result, they typically don't prosecute acts under the Computer Fraud and Abuse Act, prohibitive acts that would be below that $5,000 threshold. Now, the House Judiciary Committee did take up last year considering amending the Computer Fraud and Abuse Act to make all violations of it to be a felony. And that could be very interesting if that happens because, of course, that means there's a high probability that we'll see a lot more enforcement action under this. Okay. Now, let's talk about the Electronic Communications and Privacy Act. The one I'm most concerned with here today is Title I, and that's going to be the Wiretap Act. This is the intersection of wire communications contemporaneous with transmission. Let me tie that in a way that I think you can help understand. Some courts have held that the use of a keylogger is the interception of wire communications. So if you're actually typing keystrokes and you've installed a keylogger, in fact I have one here with me right now, I'd love to show this to you real quick. What's the matter between hardware and software? Yes, it does, in this analysis I'm going to talk about. So this here is a keylogger. And you can install this between the keyboard and the back of the computer. And this particular device, the particular model I have here, will not only capture all the keystrokes, but also provide timestamps. So I have to synchronize it before I use it. And then after that, you install it, wait till the employee leaves, go back and grab it. Now I've got passwords and everything else that they've typed only. nothing coming in. And this is completely undetectable by any kind of software, by McAfee or anything else. It doesn't show up in the registry. Now, this nice device, if you use a little key combination, will suddenly appear as a 2-gig device, and stupidly, it registers itself in the registry with the word logger. But anyway, the idea is you take it back to your system and activate it so that you can access the data. Okay, so where is my clicker? Here we are. So one other thing I wanted to talk about, we were talking about Computer Fraud and Abuse Act and ECFA, and one thing I didn't really define here was affecting interstate commerce. On the previous slide here, Computer Fraud and Abuse Act, in here it talks about accessing a computer affecting interstate commerce. I'm not sure if it's on the slide here. Please allow me to clarify what that means. We're not talking about a computer that happens to be connected to the internet, therefore it's affecting interstate commerce. And the same thing with the Wiretap Act, where it's talking about wire communications affecting interstate commerce. We're not really talking about the fact that the computers or the wire communications are somehow interstate. That doesn't matter. The reason that that language, that magic language is used is because Congress can only act pursuant to authority that it has, whether it's taxation or spending authority. And the broadest form of authority that Congress has is affecting interstate commerce. So anything that affects the instrumentalities or channels of commerce, Congress can enact legislation. And a great illustration of this is a famous old case, I think it's from the 1920s, Wizard versus Filburn. And what this case was about, it was about farmer Filburn, who was growing corn. And at that time, Congress had passed an act limiting the amount of corn production that farmers could do. And it turned out that farmer Filburn had exceeded that threshold and had produced too much corn, and he was prosecuted. And he tried to argue that this statute does not apply to me because I'm not selling my corn in the marketplace, and therefore I'm not affecting interstate commerce. I only grow my corn for my cows, to feed my own cows. Well, the United States Supreme Court disagreed with the farmer and said, no, you are affecting interstate commerce. Because of the fact that you're growing so much corn for your own cows, you're not going to the marketplace to buy corn. And therefore, if we allowed all the farmers to grow their own corn and feed their cows, they're not going to the marketplace. That affects supply and demand. That's interstate commerce. Another example that kind of is the opposite side of this is a case called Lopez, where it was held that it was unconstitutional for Congress to legislate handguns near school campuses because that just didn't have enough of a nexus to interstate commerce. The very fact that you buy a gun, sure, that affects interstate commerce, but the fact that you would carry it in or around proximity to a school really has nothing to do with interstate commerce. How does this tie up to computers? What we're saying here is that it doesn't matter how you use the computer. It could be sitting in a basement. It might be a home network that has no outside connectivity whatsoever, and you happen to go visit a friend's house, and like Sam here, you somehow hack into it. Okay? That would be a violation of the Computer Fraud and Abuse Act. Why? By the way, I know this is a recording. I need to clarify. Sam is an instructor who teaches violent Python hacking. It's a great course. I recommend it to anyone. And Sam is very expert on the topic, and that's why I mentioned his name. Sam does not engage in any illegal hacking, I assure you. Moving on. So the fact that you've bought the computer at Best Buy or on Amazon or whatever means you have affected interstate commerce. And therefore, this act applies to your router, to your hub, to your switch, to your cell phone, to your iPad, to your MacBook, to your desktop computer, your tower computer, whatever it may be. I should also add here the Computer Fraud and Abuse Act, when it's talking about computing equipment, applies to all of those aforementioned devices. Okay, it can apply to any sort of a computing device, any sort of a network device, a switch, a router, you name it. Even probably a power conditioner if it has firmware on it. It could apply to Blu-ray DVD players that are connected to the internet that can download firmware or that have the ability to stream in Netflix or streaming music or whatever. Okay, other statutes that I think we want to be concerned about are privacy statutes. And you're going to find a very interesting way in a minute when we talk about various approaches to retaliatory hacking. You're going to find a very interesting way that this statute gets implicated. In fact, I'll give you a clue, honeypots. Start thinking about that. How could honeypots possibly implicate data privacy and breach notification? Well, anyway, California and Minnesota have some rather robust statutes regarding the handling of private data and mandatory data notification or data breach notifications in the event of a breach. Then you have corporations who are governed by PCI, payment card industries. This is not a statute, it's a contractual agreement with Visa and MasterCard. You have Gram Leach Blilely, which is an act that governs the banks and financial institutions and their obligation for security and confidentiality of the data that they handle and customer data. You also have the FFIEC Examination Handbook, which is a government agency, the FFIEC, that conducts examinations and audits for information security and appropriate controls. You have the Security and Exchange Commission. So anyway, when we talk about privacy, there are some statutes here that are going to be implicated, as we'll see in just a moment. Now, Title II of EPA, we're not going to spend a lot of time on. This talks about your email that you have stored, I hate to use that word in the cloud, but let's say on an ISP's machine or server. And I believe that the statute, I don't have it in front of me, but I believe it actually uses the word provider or internet server. It's not internet, but it uses the word provider or carrier. So if you were storing stored messages on Hotmail, Gmail, Yahoo, that's what this talks about. It's a limitation on police requiring them in certain circumstances to obtain an administrative subpoena. In some situations, they have to notify the owner of the account. But in any case, it criminalizes you from hacking in to an internet service provider to gain access to someone's account. This comes up a lot of times in divorce cases, for example. Somebody can, let's say, for example, install a keylogger on a spouse's machine that might not even be divorced yet. But they're thinking about it, or maybe they're concerned that the spouse is cheating. They grab those Hotmail credentials or Gmail credentials. They then go out to Gmail and log into the account using the stolen credentials from the spouse. And in fact, that is a violation of the Stored Communications Act. It really doesn't come into play with retaliatory hacking, and you'll understand the logic of that in just a few minutes. So we're not going to spend a lot of time talking about the Stored Communications Act. We're more concerned with the Wiretap Act. Okay, then we have ethics. So the one that I most care about, of course, as a lawyer, are the model rules, the ABA model rules, which are adopted substantially in all states. So the rules of professional conduct they refer to, every state has them. And the ones that I care about are these three that I have up here. Rule 8.4c prohibits a lawyer from engaging in any conduct involving dishonesty, deceit, or deception. Why would that matter? Well, as we talk about some of the approaches for retaliatory hacking, they do involve acts of deception. Now, the Supreme Court has expressly approved of deception as a valid law enforcement activity. But lawyers can't do it, period. Cops can do it. Private investigators who are non-lawyers can do it. You can do it. But attorneys can't do it. And likewise, because of Rule 5.3, which is an attorney's duty to supervise non-lawyers, if an attorney knowingly acquiesces or directs an agent, such as a private investigator or a forensic examiner, to engage in conduct involving dishonesty, deceit, or deception, then that conduct is imputed to the attorney. And then finally, we have Rule 1.2, which an attorney may not counsel a client to engage in criminal or fraudulent conduct. We also have the codes of ethics. The most notable one, I think, for me is the ISC Squared Code of Ethics, but any of the certifications, whether it's EC Counsel, Certified Ethical Hacker, or whatever, the Certified Forensic Examiner, the Certified Fraud Examiner, all of these organizations have their own codes of ethics. Unfortunately, there are no statistics concerning enforcement or violations of these codes of ethics. Most practitioners that I know remember vaguely something about the code of ethics that they had to sign when they got certified, and they don't know anything about it beyond that, which is a real concern. So the code of ethics certainly are going to be implicated by retaliatory hacking, and when we start talking about the approaches in a moment, I think you'll begin to see how and why. I'm not going to dwell extensively on what codes of ethics mean and what their importance in the utility and society is. If you're interested, I've written an article called Professional Ethics in the Digital Forensics Discipline. You can just Google that, Professional Ethics in the Digital Forensics Discipline. It's a two-part article, and I go into a whole lot of detail and philosophy and theory about what ethics are and what the balance and counterplay of ethics with morals and law is. It's a little bit outside of the scope of what we are going to talk about and what we have time for today. Now, we're going to talk about these approaches, active defense approaches. These are the most common ones: beaconing, sinkholing, honeypots, and retaliatory hacking. Okay, so let's talk about beaconing first. Beaconing is a mechanism by which you can have a document or a piece of software phone home, so to speak. The most common one I like to talk about is web bugs. And web bugs is where you take an email. It was first really pioneered by spammers. And they put a 1 pixel by 1 pixel GIF into the email. And really, they don't put it in the email. It's an HTML request to a server to download. And so what happens is when you open up your email, you don't see an image, nor do you see the code behind it requesting the download from the server. But when that HTTP post occurs, what they're doing is they're sending your IP address information, your display resolution, your browser type, and so on and so forth to the server, so that the server knows how to render this image to you. Of course, when it gets rendered, you won't see it because its purpose is not really to render an image. Its purpose is to collect information about you to see that you've opened up the email. And once they see that you've opened up the email, they now know that this is a valid email address, and now that can be sold and added to other lists and sold to other spammers. Well, it's also used by some really cool services like readnotify.com. I've been using it for years before I became an attorney. Because it involves acts of deception, deceit, and dishonesty, because the recipient doesn't know that you're tracking them and seeing when and if they open the email. Now, this technique is starting to have diminishing returns because in recent years, most of the email clients, including Gmail and others, by default now disable images, but they didn't used to do that. You had to go in and turn off images by default. So here's a great way to use Read Notify to get around that possibility. By using the Read Notify service, where you subscribe, you pay a $4.50 fee a month, I think it is. You write your email, you append the sender or the recipient's name with readnotify.com. It goes through their servers, it's resent out, looks like it came from you, and their server will do all the tracking for you and send you the notification. When you send the email, you can include a Word document or a PDF file. And the cool thing about the Read Notify service is it will place a unique GIF on each page of your Word document or PDF file so that you can see when the recipient opened it and what page they got to. Now, the reason it's a cool technique, notwithstanding the fact that images are now disabled in most email clients, is because most people, when they install Acrobat Reader and Word, instructed their firewall to permit it to access the internet. Now, anybody here who's installed SolarAlarm or any one of the other tools, Windows Firewall, you know how chatty it is when you first install it. The first thing it does is say, Acrobat Reader wants permission to access the internet, yes or no, and you say yes. Microsoft Word wants access, or Microsoft Office wants permission to access the internet, yes or no, and you say yes. And eventually you just keep saying yes unless it's something that you don't recognize. Well, you gave permission to those programs long ago to access the internet. So, Microsoft Word and Acrobat Reader also will attempt to download this GIF, and in so doing will transmit your IP address information and so forth. Now, if you happen to be at a Starbucks location, that might not be particularly valuable. If they're trying to track your physical location, if you have a Comcast or a Roadrunner or a Cox service, the IP address that they'll receive is going to be just one that's shared as part of the pool. It gets reset every time you reset your router. But nevertheless, they will be able to see that you in fact opened that document. Now, one legitimate use for this is that you can use a service like that and plant web bugs into documents that you're concerned might get leaked out. Maybe you are in contract negotiations with an opposing party. or with a business entity, and you say, hey, I've got some intellectual property in this document, please do not forward it to anyone. And you send it out to that individual, you see that the individual opened it, but the individual disregarded the instruction and instead sent it off to 4 or 5 other people or whatever, you will be able to see those other IP addresses now start to show up. Now, of course, if that entity happens to be within a corporate firewall that uses NAT, you're still only going to see one IP address, and you're not necessarily going to see a whole bunch of other people opened it. You'll see that it got opened many times, but you won't be able to distinguish that it was many people. But nevertheless, it's a great tool. Other examples of beaconing you can imagine might be VB script or JavaScript that's embedded that might take down the server. Now, how nefarious is that? Would that involve the computer fraud DSEC? Absolutely it would. So if you had intellectual property in code and you were afraid that somebody might get it, maybe the code was intended to self-destruct and take down the server that it was on. Should that code ever get out? Or should that code fail to, you wrote a loop or something in there where you asked it to contact a local server internally, and if it failed to do that, then, it did something nefarious. That would be a violation of the Computer Fraud and Abuse Act, and that's another type of beaconing that's far more nefarious that would be illegal, whereas the web bugs are not likely to be illegal. However, they are deceptive, and for that reason, I do not believe that attorneys can or should use them or direct others to use them. Okay, sinkholing. Sinkholing, I'm going to talk about the simplest form of sinkholing, the garden wall approach. This is where we're dealing with botnets like Zeus and Citadel and others. I don't really have time to define what a botnet is here, but sinkholing would be the act of redirecting all of the traffic that is intended to go back to the command and control server to you instead. And this can be done through DNS routing. If DNS is the only manner in which this is done, it can be done through IP address routing, which is the walled garden approach, but it requires the acquiescence and facilitation of the internet service carriers, which you're not going to get. There are some legal limitations on their ability to do this. They're not going to be able to do it without a warrant. So the reason for the Zeus and Citadel botnet takedowns is because you had the FBI working with Microsoft and IBM and others. So this was a thorough investigation where they were able to pull this off. To the best of my knowledge, you could not pull off sinkholing without the cooperation of ISPs or without violating the law. Sam, if you happen to know of a way to pull this off without the cooperation of ISPs, I'd love to hear about it.
Well, they do it in China all the time with BGP hijacking. They've done it several times to us. They reroute traffic to a central point.
Okay, so in China, not here, right?
No, it affects the whole world, and anybody can do it. There are 2 million administrators that have BGP access.
Oh, and this is because it's routing through China instead of...
No, you can send out BGP updates and cause any IP address to come to you anytime over the internet.
Okay, let's talk about this offline.
But it's completely illegal, of course, but it's technically possible.
Let's talk about this offline. This is good information. Honeypots. Okay. Honeypots. Let me give you a great definition here for honeypots. I don't have this one committed to memory, so I'm going to read it to you from my article. Okay, this is a great definition. This one comes from SANS.org. And it's defined as a computer system on the internet that's expressly set up to trap people who attempt to penetrate other people's computer systems. It arguably is best thought of as an information system resource whose value lies in the unauthorized or illicit use of that resource. That's a very succinct definition. Now, what we're really talking about here is you set up a network, might even be just a server, a single machine, that is intended to either act as a lure away from your network, or, alternatively, it's used for you to collect information about the tactics, techniques, and procedures, the TTPs that the hackers use. And you can observe them, obfuscate, you can delay them, you can gather information about their TTPs. There's a variety of uses. Another one, as I mentioned earlier in the presentation, was honeypots. This is where you seed a legitimate database with invalid credentials. And then if those credentials are ever used, you now know that that database has been compromised. Now, how could this possibly implicate anything that we've talked about? Well, let's think about it. First of all, what if your honeypot happens to be intercepting a whole bunch of network traffic, and some of that traffic happens to be governed by HIPAA or other data privacy laws? What are you supposed to do with that data? you may now be required to dispose of that data in a certain manner, or be subject to breach notifications. You may be subject to some affirmative duty to have to notify customers, whether your customers or perhaps someone else's. Here's another example. What if you have a very poorly implemented honeypot system, and it's now used as a leverage point to get into your legitimate real network? Okay. What are the shareholders going to do about that? How are the boards going to react to that, boards of directors? Another example is that, so you gather a whole bunch of really useful and helpful intelligence about attackers, and now arguably you have a duty of care. You have to do something with it. You have to act on it. Okay, and if you don't, shareholders find out, customers find out. Okay, there's now a trend of folks suing over cybersecurity breaches. So several banks have sued Target, and Federal District Court in Minnesota has refused to dismiss that suit. There's also a number of suits by customers against Sony right now. It's a class action lawsuit. I shouldn't have said a number of suits. One class action lawsuit against Sony Pictures for that breach. So if it comes to light that you learned information based upon a honeypot, even if without that information, it would not have risen to a standard of care where you needed to do something. But now, because of the honeypot, you've learned about something you should have patched, you should have hardened the perimeter, whatever, and you failed to do so. That could create some liability. So honeypots surprisingly do create liability and problems.
Quick question about sinkholing. A standard practice is to drop certain IPs off your routers and also to not accept certain traffic into your email address based on black hole lists. Where does that fall in your definitions?
Say it again.
A standard practice in routing is not to accept certain IP addresses,
right, like based on
North
geographic
Korea,
location, for example,
or to accept certain, accept email from Romania, for instance,
yep.
in your email system,
yep.
based on black hole that changes on a daily basis.
Right.
If you subscribe to those services,
right,
where does that fall in your definition?
I don't off the top of my head see any kind of a problem with that. I don't regard that as sinkholing, not redirecting traffic.
There could be somebody from an EDU in Romania trying to email me, but it goes out of my email system.
You're not accepting it. Are not allowing that traffic on the firewall. I don't see a problem with that. Remember, under the Electronic Communication Privacy Act, the Wiretap Act, you are one of the parties to the communication, and therefore you can intercept those wire communications. Obviously, you can dispose of them, you can block them, you can prevent that traffic. In fact, even the ISPs themselves have the ability to do this. They won't do it. They have the ability to do deep packet inspection. There's something called the provider exception to the Wiretap Act that says that if it is necessary for the rendition of services or to protect their networks, then the ISPs themselves can actually do deep packet inspection. But they're not doing it. Why? Well, as one guy explained to me at a recent conference, at a MIST conference I went to, he said, because it pisses off our customers, quote unquote. Some like to throw out legality. Oh, well, we're not allowed to do that. Well, in fact, they are. They can do it. There's no revenue for them, so why should they do it? Now, some of the ISPs are beginning to recognize that they can collect data analytics about attacks as they're occurring. We're not talking about deep packet inspection. We're talking about SIM flood. We're talking about DDoS and threat intelligence sharing about particular IP addresses. And they're able to take that information and package it up and monetize that. And so not just on your network, but on all of their customers' networks, and collectively monetize that and then sell it back to you. Okay. So some of the, I'm going to talk about some of the risks of retaliatory hacking, but here I just kind of want to talk about the concept of hackback itself. This is the most nefarious and clearly illegal conduct, and this would be actually taking down servers, doing port sweeps and getting into an opponent's server if you think you successfully accomplished attribution. There are a number of risks to this aside from the legal risks. One of them is misattribution. Many times the hackers will use a victim's system. That's certainly the case with botnets. It's very, very difficult to attribute on the internet, in the cyber world, who the attacker really is. So there's a tremendous risk of inflicting harm on an innocent party. And that's the collateral damage aspect that that's mentioned up here in the slide, the fact that you could inflict harm on an innocent party. Okay, let's talk about some of the defenses that have been offered. Recaptured chattel. So this is the idea that if somebody steals your property, you have a limited privilege to take it back. And it goes something like this, and it's a very limited privilege, by the way, in the common law. So if you're in public and someone steals your umbrella, you have the right to use reasonable force to take back your umbrella. But there are a couple of requirements. One is that you have to be in hot pursuit. The second, of course, is that you can use no more than reasonable force to take it back. If you lose the thief darts into a store and then comes out the back of the store, and you catch up with him 5 minutes later, most courts will hold that you are no longer in hot pursuit. You lost the privilege of self-help. You have to call the police. You can't take your umbrella back with any amount of force. Okay? So some folks have said that, hey, someone steals my property, my intellectual property, let's say, the recipe for KFC or for Coke or whatever, and I have a way to get into their server to take it back, then I can do so. Well, I'd like to offer a different example that I think most of us will appreciate. Let's say that you bought a really cool, unique television only available in Japan. It's a really awesome widescreen TV. You cannot buy it in the U.S. market. You had it shipped over specially from Japan, and it's very distinctive. And someone has stolen that from you. A week later, you're walking down the street, walking your dog, and you look into a neighbor's front window, living room window, and you see your television. Can you break into your neighbor's home to take your television back? Does anybody here think you can do that? Right. So,
Wait.
Go ahead.
I can.
You may not do that.
No, I can do it. The question was, can you?
Okay, thank you. Thank you for that.
Please continue.
Poignant clarification. Private necessity. This is the idea that that necessity can allow you or provide you with some sort of a limited privilege to trespass on property, for example. So an example of this would be, let's say that your car becomes disabled in the middle of a snowstorm. You can temporarily trespass in order to save life or limb and put your car in someone's driveway until the storm has passed and the roads have been cleared and your car has been recharged and you can take it back. You would be liable to the property owner for any damage that you may have caused, but you have a limited privilege to do that. The Castle Doctrine, I really don't see any applicability here, but some folks have tried to offer this one. This is, of course, in some states where you can use deadly force to eject someone who's about to commit a felony, that you have reasonable suspicion or reasonable belief that they're going to commit a felony or injure you, life or limb in your home. And then we have a novel argument called the private security guard doctrine. This is the idea that, for example, if you park your car at a football stadium to go see a game, it's private property. While you're there, a private security guard sees an illegal weapon or drugs or contraband in the backseat of your car, that the security guard can then break into your car, take that evidence, and then give it to the police, and it's not subject to the Fourth Amendment because it was not done at the direction of the police, as long as it was done within the scope of employment, even if it was unreasonable. So the idea here is, well, okay, so I'm not working with the cops. I see that there's a malicious attack going on my network. So while it is occurring, they're trespassing within my network. I have the ability to disable that attack, not merely stop it or block it, but disable it, which could perhaps include getting onto their network and doing something nefarious to them, taking down their server, whatever the case may be. There's a more detailed discussion of that in my article if you're interested in reading it. All arguments, in my view, bear stretch marks, and none of the proponents of these arguments have offered any sort of indemnification. One of them is the esteemed Stuart Baker, former NSA counsel who now works in D.C. as a cybersecurity attorney for Steptoe Johnson. Another one is a guy by the name of Wilson, is his last name, and he runs the Titan Security Group out of Denver. Both of these guys have offered these and other defenses for retaliatory hacking.
Wait, quick question, go back
Yep.
one slide, please.
Okay.
Is a private security guard, is that a generic term or is there a legal definition?
That's a legal term of art right there, the private security guard doctrine.
So if I'm hired as a security expert by a private company to guard their electronic data, am I considered a private security guard?
For the purposes of this doctrine, you could be. But beyond and outside of this context, none of us here in the room, or any of us that do information security, would consider ourselves to be called security guard. This is not a corresponding chart of line by line. It's designed for you to sort of draw lines, multiple lines if necessary. So as you look at each of the approaches I talked about, draw some lines over here. So does beaconing have a legal risk? Probably not. Except for maybe data privacy, which I talked about a minute ago, and breach notification. What about ethical risks? Perhaps, if it's poorly implemented. What about escalation? Maybe, depending on the attacker, if you aggravate or provoke the attacker. Now, if it's a cyber thief, he's going to move on to low-hanging fruit and leave. But what if it's a hacktivist? What if it's a nation-state actor and they discover that your honeypot was been wasting their time for a week and all of their resources? They might get very angry and double up their efforts against you. So yes, beaconing could involve escalation. Does beaconing involve misattribution and collateral damage? No. Could it harm goodwill and reputation? Sure. If it's poorly implemented? Yeah, absolutely. And it gets out in the news. Threat intelligence gathering. I didn't get to talk about that. We're out of time. If you want to talk about it with me afterwards, it's a very benign form of active defense, and yet it does carry a number of risks here, including legal risks, certainly ethical risks. That's why a number of companies are using Israeli operatives. They use RSA, they use IBM Trusteer, they use other companies in Israel that can skirt U.S. law to be able to engage in various types of threat intelligence gathering that would otherwise be illegal in this country. We talked about honeypots. We talked about retaliatory hacking. Obviously, the retaliatory hacking involves legal, ethical escalation, misattribution, and can harm goodwill and reputation. Okay, I think we're out of time, so I do not have time to discuss the promising alternatives. It is in the article if you're interested in it. I'm not trying to toot my own horn, but to the best of my knowledge, the article that I mentioned to you, which is this one here at the top, is the only such comprehensive article on the topic. It probably won't be for long because this is such a hot topic right now. But everything I've talked about and more has been consolidated. And I have one more plug. It's from my colleague John Strand and Paul Lazadorian. They have this book that's available only on Amazon, Kindle download for a mere $10, okay? And it has a bunch of cool scripts and stuff in it. It's from their active ADHD toolkit, active harbinger distribution. Yeah, that's it. Active Defense Harbinger Distribution, ADHD Toolkit. Got Honey Badger and a whole bunch of cool scripts and some other stuff, and this book talks about how to write them, how to do them, how to deploy them. John Strand is sort of an advocate for active defense, so if you kind of want to see the other side of my presentation, then get the book, $10. Okay, that's it. Thank you for your time.
Thank you very much.
Thank you.